Hello everyone and welcome to this video tutorial in which we're going to be doing some revision for A-level law. In this video I'm going to be talking you through a past exam paper for A-level law, specifically substantive law in practice. So this is where we're looking at scenario or story type questions and you're having to advise the characters on the different areas of law that are involved. This video is looking at Eduqas Component 2 from summer 2022. I will do some other videos for A-level law OCA and A-level law AQA, but even if you are with a different board, scenario questions are always going to be very similar, and certainly the suggested content that you put into them will be the same whichever board you're with. So hopefully this video is going to be helpful for everyone studying A-level law. So let's take a look at the paper then. So this is Eduqas Component 2 from summer 2022, and you would have 2 hours and 15 minutes to answer a total of 3 scenarios from a different section of the paper. And you can see that Eduqas has contract, tort, criminal and human rights law on it. And you're going to answer a scenario from 3 sections. Obviously, you choose the section depending on what you've been studying at your particular college. So let's scroll down and have a look at the questions then. It's going to be a bit of a whistle-stop tour of this paper, as you'd imagine, because there's a lot of questions on here because you've got a choice of 2 for the 4 sections. So section A is contract law. So if you've been studying contract, you would need to choose from either this FATU question, number 1, or this sunrise question, number 2. And the first question is asking you to advise FATU whether there's a breach of any implied or express contract term. And I've just highlighted some of the main issues that have hopefully leapt off the page at you when you've been looking at that. Remember that I do have other videos on my channel that go through what the law is on implied and express terms in contract law, so you may want to watch that if this question looks a little daunting to you. But some main issues that you'd be looking to include is issues under the Consumer Rights Act 2015. Has it been done in a reasonable amount of time? Has it been done with a reasonable amount of skill? Whether there's a breach of the Consumer Rights Act, Section 9 and Section 11, because it's of poor quality. This statement that he's not going to be liable, hopefully you're thinking about exclusion clauses there, and remedies under the Consumer Contracts Information Cancellation and Additional Charges Regulations 2013, the 14-day cooling off period. Let's take a look at the second question then. This second one, students found a little bit challenging because the question asked you to advise David and Kate of their rights and remedies against sunrise holidays. And a lot of students saw this word remedy and focused solely on remedies such as compensation, and they didn't talk about whether there'd been a potential frustration of the contract. When you actually look at the scenario, the word frustration, or frustrated anyway, is in there to give you a clue. And it could be frustrated by this very wet weather. Hopefully Taylor and Caldwell is jumping to mind that that's potentially happened. We've also got issues here with the telephone cancellation. So you could talk about anticipatory breach because Sunrise has informed David and Kate that the college is unavailable before they're due to be there. Probably this question where it's asking you the rights and remedies makes a bit more sense when you recognise that frustration is potentially in play here, because really the question was wanting you to look at the rights and remedies for the potential breach, whether it's an actual breach or an anticipatory breach, and also whether the contract can be set aside as a result of the frustration because it can't be performed, whether David and Kate can get any deposit back, and whether they can get any further payments. And to look at that, you'd need to look at the Law Reform Frustrated Contracts Act 1943, which does make some provision for expenses incurred prior to the frustrating event. You could talk about Section 1.2, monies advanced should be repaid. etc. So conscious of time, let's move along to the next section, section B, which is tort. So again, you've got a choice of 2 questions here. And the first one is asking you to advise the characters on the law of occupiers' liability. Again, I do have several videos on my channel on occupiers' liability if you need refreshers on the 57 and 84 Occupiers' Liability Acts. I've got some videos on specifically how to apply occupiers' liability, and if you've watched those, you'll know that the first thing you'd have to talk about here is whether Lily and Sally were lawful visitors under Section 2.1 of the Occupiers' Liability Act 1957, and whether Bow has satisfied the duty of care under Section 2.2. There are signs, so you could talk about this prominent sign here under Section 2.4 of the 1957 Act, and you would think that that would be enough to enable our visitors to be reasonably safe. Hopefully you've noticed that when Sally's gone into this roped off area, she may of course have become a trespasser under the 84 Act. With this local handyman here that has fixed a coffee machine, and so we'd need to consider the liability of Lennox as an independent contractor and whether Bow can pass the liability for this faulty machine back to him under Section 2.4 of the Occupiers' Liability Act 1957. Quite a nice question that most students liked. Let's have a look at the other option that you had on tort. And you can see that this one is asking you to discuss the types of damages that would be available to the claimant. The question would want you to talk about compensatory damages and the aim to put the claimant back in the same position as if the tort had not been committed. And you'd need to talk about 2 different types of damages here, special damages and general damages. Special damages are a little bit easier because they're your quantifiable financial losses up to the date of the trial, and you'd be talking about the loss of earnings because we can see that he was self-employed and unable to work, medical expenses, but you'll notice that there's a private medical facility involved, so that's going to be a problem for him. General damages, you can talk about losses that aren't capable of exact quantification, and pecuniary and non-pecuniary damages, and you could talk about the pain and suffering that he's received as a result of this, and also talk about pecuniary damages, loss of future earnings, because he's no longer able to work. So hopefully you're thinking about the sum where they use the multiplicand and the multiplier, and the number of years for which the claimant is likely to have worked, multiply it together to work out future losses. So you needed to talk about different types of damages here. Some students went wrong on this and started advising the character on the tort of negligence. But you need to read the question carefully because it says following his successful negligence claim, advise on the damages. So as always, read your question really carefully. 3 then is criminal law, and the first option that you have here is to advise Mike as to whether he'll be criminally liable for the death of Claire. It's typically like homicide questions like this one, so you would need to start with murder, of course, your actus reus and your mens rea of murder, and hopefully certain facts have jumped out at you. I've just highlighted a couple here. We've got a junior doctor failing to diagnose a fractured skull, so hopefully you're thinking all of your causation issues that apply for murder you'd need to be discussing there as well. But it's important for this question, that when you're talking about liability for the death of Claire, don't just stop with murder, because there are other potential homicide offences that Mike could be responsible for if we can't prove, say, the mens rea for murder. We could potentially go for another homicide offence, a manslaughter offence. So you could talk about involuntary manslaughter once you've dealt with whether it's murder or not. So involuntary manslaughter, you could look at unlawful act manslaughter because, of course, Mike has done an unlawful act, which looks to be dangerous. So he may be liable under unlawful act manslaughter as well. Look at the next one. So we've got another criminal scenario here, and you're being asked to advise Abdul and Kai about any offences, making sure that you talk about any potential defences as well. So make sure you check that question. Do they just want you to talk about offences, or do they want you to talk about defences as well? And this is a question when you scan it, hopefully you can see this is non-fatal offences against the person. There's a lot going on in this scenario. So firstly, we've got a text message that makes the victim turn pale with fright. So hopefully you recognise that's a potential assault. Seconds later, someone's hit on the back of the head with a popcorn container. So that's a potential battery. And the fact it's the back of his head and he didn't see it coming doesn't matter. You don't need an assault and a battery. They've talked about settling their differences with a friendly fight. Now, this is interesting because this is where you are going to talk about a potential defense. So the characters are going to try and argue, oh, well, this shouldn't be an offense because we agreed to do it. In other words, we have the defense of consent. But hopefully you know that you can't consent to a fight in that manner. And then we've got another situation here, a loose punch, which has barely grazed the face. So loose punch looks like a battery. If that's a graze where we've actually got a mark left on it, it would be ABH, but I think this is just a battery here. We've then got a blow that's knocked out teeth. So we've got quite a high level of injury there, but you could class it as GBH or a wound. So you'd need to discuss whether that's section 20 or a section 18 there. I think much more likely to be a section 20 given the mens rea. We've then got a passerby running up to separate. There's a mistake that an attack is happening. So there's another potential defence, self-defence. And this kick in the stomach causing serious internal injuries. So again, that's a potential section 18 or a 20, and you'd need to talk about whether you've got the mens rea for specific intent, that high level of mens rea for a section 18 there, and whether self-defence will work in that context. Section is human rights law. I'll have to go super quick here because I'm running out of time on this recording. So you've got a question here, number 7, asking you to advise on defamation. Here you can see here that the defamatory statements do refer to our claimant, because when we're advising Charles, the newspaper article and the picture clearly refer to him as required by the Defamation Act 2013, because there's a picture and his name is used. And I think it's clear that the damage to Charles' reputation by the newspaper article and the photo could be considered as causing serious damage under Section 1 of the Defamation Act, because it's affecting his ability to do work. The statements, you'd need to talk about whether they've been published. They're in a paper. Are there any defences applicable? You could talk about potentially truth as a defence, but of course it's not true in this particular case. Other defences, section 4, it could be of public interest, but of course that's not going to apply. And section 3, is it honest opinion? And talk about absolute privilege for comments made in Parliament, but of course these comments were made in a newspaper. The other option on the human rights section is to advise on police powers. Question, make sure that you highlight all the different timings that have happened, because you're going to need to advise under the Police and Criminal Evidence Act 1984, PACE, Article 5 and 6 of the European Convention on Human Rights. And it's really important for a question like this that you talk specifically about the sections, section 56, 57, 58, 61 of PACE, time limits under sections 40 to 44 of PACE. Be really specific when you're advising the character. I hope that was helpful.